There isn't a company in this land that hasn't had a subpoena to respond to or a visit from the government. Visits come by either in documentary form, or they come by telephone, or they come by in-person visits. The event of someone knocking on your door, whether you're an individual or a company, is actually a good thing. Most people are extremely scared by it and think it's the end of the world, but in fact, it gives you advance notice that the government is investigating you, as opposed to suddenly appearing at the other side of an indictment and not having a chance to persuade the government that they've got the wrong view of the facts. So when they come calling, you're not to talk, you're to invoke your attorney's name, get the agent to talk with your attorney. They will be incredibly charming, that is the agent, will be incredibly charming, incredibly persuasive. They will try to persuade you that if you talk with them this one time for about 10 minutes, your life will go back to normal, you'll never see them again, and in fact, they're just well trained at trying to invite conversation. You don't want to fall into that trap. The other thing is you've got to then, after you've called your attorney to alert him or her to get in touch with the agent, you've got to start preparing to collect documents. And that's the other fundamental area that people make mistakes in. They start to think, well, maybe if I get rid of this document or don't provide that email or suddenly destroy emails, that I'll be in better shape. It's never that way. There's always someone else who received the email, and you'll then be facing an obstruction charge even if you have no other criminal liability. First thing you've got to do if it relates to company business is you've got to tell the company superiors, and preferably the company's general counsel. They'll be able to guide you through the rest of the process. It's something that lawyers deal with all the time, and so you need to pass your problem off to them. That will entail a document retention memo going out undoubtedly to all employees. It'll also be accompanied by suggestions, or actually stronger than that, recommendations that you not talk to other employees about the problem, or anybody else for that matter with whom you might have a friendly relationship but no privilege. The problem for the corporate employee will be that when that corporate employee talks to the corporate general counsel, he or she, that is the employee, will not have a privilege of his own. That privilege will belong to the company. So often you may want to even get your own personal counsel involved as an individual to interact with the company's corporate counsel. What you want to do is not go off on your own, but rely on the advice of corporate counsel, hopefully guided by your own individual counsel, if you can get the corporation to pay for that, and otherwise out of your own pocket, where you then have a coordinated strategy to make sure that all of the company's obligations are taken care of, as well as your obligations to the company.